Hi, welcome everybody. So first of all, welcome to everybody who's joined us here in Landmark Chambers this evening. Also, welcome to those people who are joining us remotely, in addition to those who are in the room. Welcome to this Junior UKELA event, which is about the Aarhus Convention, a year in review. My name is Maurici KC. I'm going to chair the session today. And I'm joined by my colleagues Jacqueline Lean, Nick Grass and Alex Shattock, whom I will formally introduce to you in a moment. Can I just give you some housekeeping notes in terms of people who are joining us virtually? Obviously, none of this affects any of you in the room, but your microphones are automatically muted, so you don't have to do anything. We do welcome questions in due course, both from those in the room and those of you who are joining us remotely. For those who are remote, you can obviously put your questions in the question and answer box that you'll be well familiar with, and we'll try and answer as many questions as we can at the end. The seminar will be recorded, and for those who are joining us, there will be a link sent to the presentation after the event concludes. And again, for those who are joining us remotely, if you lose your connection, just rejoin and you should be able to get back in. Okay, well, what I'll do is I'm going to introduce the speakers. So the first speaker tonight is going to be Alex Shattock. He's going to be doing a sort of revision course, really, on the three pillars of the Aarhus Convention. Alex has been involved in a number of the big environmental claims that you'll all be familiar with recent times, including the Cumbria coal mine case. And cases like Cox and the Oil and Gas Authority. So that's the first of the talks that we're having tonight. Then Jacqueline Lean will be doing the second talk, covering recent developments on costs in the Aarhus context. Jacqueline's been involved in a number of cases concerning the Aarhus Convention, including cases before the Compliance Committee and cases like CPRE Kent and RSPB before our domestic courts, which are focused on Aarhus costs. I will then be talking to you about non-costs Aarhus developments, both domestically and in Europe. And then finally, we will hear from Nick Grant. And Nick is going to be talking about recent developments in terms of cases before the Aarhus Compliance Committee. Nick has appeared in many of, again, the leading environmental cases of recent times, including Finch, and soon to appear in the Supreme Court in Fry. He has also appeared before the Aarhus Convention Compliance Committee. So without any further wasting of time, I'm going to hand over to Alex.
Success. What is Aarhus? Is it an international convention? Is it cost capping regime? Is it the second largest city in Denmark on the eastern shore of Jutland? Is it a state of mind? Aarhus, of course, is all of these things. Hello, everyone. Before we turn to the year in Aarhus, and what a year it's been, my word. But before we get into that, in my talk, I will be reminding us briefly of the basics, the foundations, nay, the very essence of Aarhus. Let's get into it. The convention is, of course, an international treaty ratified by the UK in 2005. That means the UK has agreed to be bound by its requirements. If you've seen my previous Aarhus Convention talk, perhaps on Landmark Chambers' YouTube channel, and why wouldn't you? Landmark Chambers' YouTube channel, very much the Mr. Beast of the environmental law PowerPoint world. Certainly it is just as enjoyable to watch. But if you've seen that talk on Landmark Chambers' YouTube channel, then you will know that the Aarhus Convention is a grand edifice supported by no less than three pillars of the Aarhus Convention. What are those three pillars of the Aarhus Convention? Access to information, public participation, access to justice. Now, I am under very strict instructions not to do what I usually do and use copyrighted images taken from Google image search, which is completely understandable. I understand why that prohibition's in place. So what I've done for this presentation is create my own images using the time-honored artistic medium of Microsoft Paint. Just so you're aware, this is in fact the first time any of these Aarhus-related images have ever been seen in public anywhere in the world. It is just for UKELA. So the UK has agreed to be bound by the convention and its 3 pillars, but signing up to international obligations does not automatically make them enforceable in the UK courts, unlike some other countries. Here there needs to be a further step. The treaty obligations need to find a home in domestic law for them to be directly enforceable. The Aarhus Convention is not directly incorporated in its entirety into UK law. What we find instead are the various requirements of the Aarhus Convention scattered like the body parts of Osiris across the UK's legal landscape. And here's where we find them. Pillar 1, that's largely EIR via the EU legislation that this legislation was intended to transpose. We'll come to that. Pillar 2, all over the place really, but basically it's the consultation requirements for EIA and SCA found in the Town and Country Planning Act 1990 regime, Planning Act 2008, the Marine EIA regime, all those opportunities for the public to participate in decision making. All that helps to meet these requirements. Pillar 3, which Jacqueline will touch on, is about being able to challenge decisions. We find those requirements largely in the CPR, which provides for a bespoke cost capping regime for environmental claims to ensure members of the public can actually get to court. Turning to those pillars, I've already forgotten how many there are. There's at least one though. Pillar 1, access to information. That's Article 1 on that slide. You can see it there. I won't read it out. Would you like to access some environmental information? If so, Pillar 1 is your pillar. The drafters of the convention, what did they do? They drew heavily on Council Directive EU 9313 on the freedom of access to information on the environment. So the Aarhus Convention in part has a basis in EU law, but they didn't stop there with Directive 9313, the drafters of the convention. They went further in the Aarhus Convention, but as a consequence of the Aarhus Convention going further, Council Directive 9313 was then insufficient to comply with it. So the EU went and updated it in line with the Aarhus Convention. They brought out Directive 2003-4, and the UK transposed that directive via the 2004 regulations a full year before we ratified the Aarhus Convention. So we did our homework well ahead of time. Good job, UK. We also see on this slide there are 2 limbs in Article 4 and 5. You get your environmental information on request, Limb 1. The government needs to collect the information too. That's Limb 2, and that makes sense. It wouldn't work otherwise. Can I have this environmental information, please? No, I'm very sorry. You don't collect it. That wouldn't work, would it? The drafters, they knew this. Still on Limb 1, requests. Article 4, you make a request. You're entitled to all of it, all the information, not just the government summary of the information. Just imagine if that were the case in judicial review proceedings. Imagine if you got all the information you asked for, but alas, one day perhaps. I'm still waiting to see the ministerial submission in the Cumbria coal mine case, which I spectacularly failed to compel the government to disclose, the government ably represented by Nick Grant over there. I'm certain it is absolutely damning. But one day we'll know the truth. Information must be provided in the form requested. Now that's what's on the slide, so it must be true. But I think there must be limits to that. If I requested HD DVD rather than Blu-ray, surely you would think, surely there are limits to the format you request. On that subject, my dad offered up his old Sega Mega Drive 2 on the family WhatsApp group yesterday, and there was a lengthy discussion about the kit required to get it working on a modern TV set. We settled on a SCART to HDMI converter. It was the longest interaction I've had with my family in months. Regrettably, though, we were unable to find a clear solution to the lack of a native save function on most of the Mega Drive games, an obvious design flaw. The idea that anyone could complete Ghouls and Ghosts in one session, frankly, ludicrous. I digress. Time limits for providing the information as soon as possible, but within a month. Exemptions, they are various. We have them in Article 4.4 and 4.3. The Article 4.3 exemptions on this slide, they look remarkably similar to the exemptions under Regulation 12 of the Environmental Information Regulations, don't they? Uncanny. Other exemptions in Article 4.4, also on this slide. We will circulate the slides afterwards, of course. A fairly chunky list on this slide, but they're all subject to there being an adverse impact on the protected interest in question. Article 5, this is the active information gathering requirement, gathering information. That's what this is about. Government also needs to keep an electronic database, quite onerous, quite prescriptive. And there are also requirements about providing administrative assistance in accessing the information. Finally, Article 7, the government has to publish facts and an analysis of facts, which the government considers relevant and important in framing major environmental policy proposals, worth bearing in mind if you're working on or seeking to challenge major environmental policy proposals. That's pillar 1, first pillar of the Aarhus Convention. It's gone, it's over. We're now on pillar 2 of the 3 pillars of the Aarhus Convention. Pillar 2 is about public participation. But before we get into that, here is a drawing of the old town in the city of Aarhus. I don't own the copyright for any images of Aarhus Old Town, so I created my own. Probably the most accomplished drawing I've ever done on Microsoft Paint, or indeed at all, I think it's fair to say. As you can see, very typical austere Scandinavian architecture, a bit of greenery, nice river going through it. What's the river called? I hear you ponder. Actually, the river is called the Aarhus River. The city gets its name from the river. Little Aarhus fact for you there. Pillar 2 of the convention. We'll find pillar 2 in Articles 6, 7, 8 of the Aarhus Convention, not Article 9. That's the third pillar. Hold your horses. And basically, we find these obligations are met all over the place in the various statutory consultation requirements for decisions and policies that might affect the environment. The public need to have enough information and they need to be able to influence the outcome, EIA, SCA, and what have you. Now, there's an obvious potential clash lined up between, on the one hand, the government's ambition to speed up development approvals, and on the other hand, the public participation requirements of the convention. We'll see what this government brings forward, but one could well imagine a complaint to the Compliance Committee brought off the back of any reform that cut down the ability of the public to participate in environmental decision-making. So watch this space. That's pillar 2 in brief. Third pillar, we're almost there. Access to justice. But first, we see on this slide my final bespoke image. This is a powerful visual representation of the Aarhus Convention as some kind of hero, unidentifiable for copyright purposes, kicking open the door of the court for members of the public. I'm quite moved whenever I look at this image, which is not infrequently. Just leave it on the screen for a little longer. Sorry, I can't resist. No, okay. Article 9 covers this third pillar. Pillar 3 of the Aarhus Convention, and basically says there needs to be a right to challenge decisions of various different kinds. Information decisions, we comply with that in the UK via a right of appeal to the ICO. Permitting decisions, we comply with that by a right to challenge planning decisions in court. Other acts or omissions by private persons and public authorities, that last one arguably not fully complied with by UK law at the moment, given the lack of cost protection for nuisance claims as of right. We'll see a bit later in James's presentation about the UK government's recent consultation, which covers that. Of course, the big impact of Article 9 is the way it modifies our domestic adverse costs rules, as Jacqueline will discuss. It also has implications for standing, as members of the public concerned need to be able to challenge decisions. So if the standing rules become further restricted in future, Aarhus could be a useful stick to hit back with. Final thought under Pillar 3 of the 3 pillars of the Aarhus Convention. There needs to be a right to challenge the substantive and procedural legality of a decision. Substantive legality. Does that align with the Wednesbury unreasonableness standard of review in judicial review proceedings? As long as the decision isn't mad, the courts won't attack the substance, generally speaking. Might there be an issue here? There might. But basically, so far, the UK courts at least have said it's all fine. Will that last? Will the Aarhus Convention Compliance Committee agree? Well, I'll let James and Nick tell you, but I'm confident that they are as sceptical as I am about the future of Wednesbury unreasonableness. It's quite clearly a relic of a bygone era. That's it. That's the 3 pillars. We've done all 3. I'll now hand over to Jacqueline for last year's domestic decisions on cost caps and the scope of an Aarhus Convention claim.
You for that, Alex. Unfortunately, I have neither Alex's PowerPoint paint skills nor his unique method of delivery. In fact, I was speaking to Nick earlier and saying that I feel like, when there's a disco at Christmas or that slightly awkward wedding where, there's a big burst of energy where it all kicks off and it's crazy and everybody's on the dance floor. And then the DJ loses his way slightly and all goes a bit quiet and people start sloping off and going and get a drink from the bar. This is this lot. And then the energy is going to ramp up again dramatically with James and Nick. But what I'm going to talk about is something a little bit dry and dusty, but actually really quite important in terms of mechanics of bringing or responding to claims that have the necessary environmental element to bring them within the domestic cost capping regime. So the starting point, Pillar 3, Article 9, Article 9.4. The requirement that the procedures to challenge decisions that might fall within Article 6 of the EIA directive or requests for environmental information or otherwise challenging provisions of the national law related to the environment shall provide adequate and effective remedies, including injunctive relief as appropriate, and be fair, equitable, timely, and not prohibitively expensive. And for 4 words that I'll talk about something not being prohibitively expensive, it has generated an extraordinary amount of drafting and legislation and case law challenges, both domestically and before the Aarhus Compliance Committee. But that requirement that proceedings be not prohibitively expensive is what has spawned the domestic Aarhus cost capping regime, which for many, many years was happily ensconced in Part 45 of the CPR, and then decided for some reason to up sticks, move itself to Part 46 a few months back, thus causing great confusion for absolutely everybody when they were rewriting skeletons or cutting and pasting into statements of facts and grounds or summary grounds of defence. And suddenly had to go back and check all the numbering because it all changed slightly. But as I said, they're now found in Special Section 9 of the CPR Part 46, which deal with costs special cases. I'm not going to go through all of them. I'm sure you've all read the CPR. If not, it's very easily available online. And so it's probably not helpful for me to read it at you laboriously. But I'm just going to pull out some key parts for the purpose of what I'm talking about next. Firstly, this definition of Aarhus Convention claim. Now, this has been a bit of a bugbear since it was first introduced. And I don't think we're done with it yet. But where we are now is that an Aarhus Convention claim is a claim brought by one or more members of the public, by judicial review, or that should read review under statute, which challenges the legality of any decision, act or omission of a body exercising public functions, and which is within the scope of Articles 9.1, 9.2 or 9.3 of the Aarhus Convention. Now, in theory, that should look straightforward. We've had the Aarhus Compliance Committee and the domestic courts weighing in on what's meant by members of the public. It's still not entirely clear. We've had issues about judicial review or review under statute and what is or isn't in there. We've had issues about what is within the scope of Article 9.3 of the Aarhus Convention in particular. That's usually the one that you get the fights about. Is this provision of the national law relating to the environment that's alleged to have been contravened? And we've also occasionally had a little bit of fun with putting it all together and what does it mean and how does it work? But this is the starting point when you are bringing a claim and you are thinking about, can I get cost protection? And it's the starting point if as a defendant you're going, actually, has there just been a bold assertion that this is Aarhus because it looks a bit planny-y or it looks a bit landy? Actually, is this claim really one that falls within the definition? Now, in terms of members of the public, we're helpfully told that that's to be construed in accordance with the Aarhus Convention, which really isn't very helpful at all. If you go and have a look at it, it's quite broad and quite general. So go to the domestic case law if you're stuck. And the section applies to two types of appeals only. Those under 289, so appeals, statutory appeals, where there's been an appeal against enforcement notice, and section 65, one which is sort of a comparable provision for the Planning, Listability and Conservation Act, and they're treated as if they're reviews under statute. So you'll probably see a bit floating around. In fact, I think I'm guilty of saying it on more than one occasion. Most planning cases fall within or are thought to fall within the Aarhus Convention or that definition. You just need to double check actually that your planning decision that you're looking at either is a JR, a review under statute, or it's one of those two appeals. Now, CPR 46.25 tells you what is, essentially the starting point for when is this an Aarhus Convention. It's important to bear in mind it doesn't automatically apply. The court is not going to direct its mind of its own volition to, is this an Aarhus Convention claim? Should I be looking at a cost cap? If you want the protection, the claimant's got to say, this is an Aarhus Convention claim in their claim form. And they've got to have filed and served a statement of financial resources. And again, I've not given you all the gubbins about that because I'm sure you're familiar with it or it's set out in the rules. But this is about what are the financial resources that I have or are available to me, say from third parties or others, that I can draw on in respect of this claim. And it's also important to bear in mind is even if something is obviously an Aarhus Convention claim, a claimant is not obliged to seek a cost cap. And this is something I've seen in a couple of cases I've dealt with where I've got a public sector client going, hang on, we're suddenly looking at a £350,000 cost bill on an environmental claim. Isn't this really an Aarhus claim? You go, well, probably, but the claimant didn't tick the box, didn't file a schedule of financial resources because they obviously don't want the protections to apply. So it's on the claimant to say, I want this. It's not for the defendant to be able to say, well, hang on a second here. This looks like it's an Aarhus Convention claim. Can we have the default cost caps, please? Because that would help us out a lot. The rules specify the default cost limits. They are still and currently 5k for an individual, for a claimant, 10k in other cases. So if you're a limited company or such and such. And for the defendant, it's 35,000. So that's the extent of the liability there. And it's really important to bear in mind, and we'll touch on this in a few minutes, that in a case with multiple claimants or defendants, the limits apply to that party individually. So an individual claimant's liability is only ever £5,000, regardless of how many defendants there are. It's £5,000 exposure to D1 and to D2 and to D3. Well, at least at the moment. 46.27 is where you get into the ability to vary the default cost limits. The court may vary the amounts or remove the limits, but again, only on an application that's made in accordance with the rules. So this is not a court of its own volition going, well, we think these look a bit dodgy here. There's a requirement for it to be made on application. And it can only make that variation if it is satisfied that A, to do so would not make the costs of proceedings prohibitively expensive. See, nice use there of the language in the Aarhus Convention, because nobody quite knows what it means, so let's just use the same words to help we figure it out as we go along. But B, that in the case of a variation which would reduce the claimant's maximum liability or increase that of defendant, without the variation, the costs of the proceedings would be prohibitively expensive for C. I was slightly flippant when I said nice use of the language, because we'll figure it out as we go along. There are a list of factors in CPR 46.27 that need to be looked at when deciding if costs are prohibitively expensive. There's a subjective element. Would it exceed the claimant's financial resources? And it's also, would it be objectively unreasonable, having regard to things like what's the claimant's interest in this? How complex is this? Does this have legs, or does it look a bit frivolous? Things like that. Something also to bear in mind, and I don't think this has been thoroughly bottomed out yet, but I've had something recently where a claimant has said this is an Aarhus Convention claim, and given a very rough, very reason to a case where it's also the same case as had the cost cap awarded, and the defendant's gone, well, hang on, it's for you to explain why this is, and the claimant going, well, hang on, it's actually under the rules, it's for you to say why you deny it's an Aarhus Convention claim. So I'm not sure that one's ever been thoroughly bottomed out. I've not seen any guidance kicking around about, well, who's actually got to set out what this is, but my view is always it's sensible if you're the claimant and you're saying it's an Aarhus Convention claim to at least say briefly why you think that it is, and if needs to be by reference to which of the 3 articles in Article 9, 919293, you're saying it falls under. Appeals. There's also the cost of protection, of course, for appeals. Didn't used to be there, got introduced because people went, oh, hang on, what do we do? You've got your nice 5k cap below, but what happens if this ends up going on appeal? So there's now a comparable provision in 5219A that where, and again, this is an onus now on the court, that where an appeal is made in a decision where there has been the cost caps below for the claimant, then the court must consider whether the cost of proceedings would be prohibitively expensive for the party who was a claimant, and if they would be, make an order limiting the recoverable costs. Now, there isn't the same as you have in the first instance proceedings, a default cost cap that applies. Often in practice, what I've tended to see is people either saying, well, it should be the same cap as below, so it was 5k, 35k, apply the same cap, so it's another 5k, another 35k. I've also seen cases of people going 5k is the absolute maximum. Essentially, it should almost be a nil cost jurisdiction in the Court of Appeal. I've not usually seen that one succeed in the absence of an agreement, but from my experience, the court's often used as a starting point. Well, what was the situation below, and what are the default limits? Let's use that as a bit of a starting point. So that was a bit of a very rough run through some of the relevant bits in the rules that it's useful to be aware of. Some points to remember. So this is the pre-last year's roundup, but some quite important points that have actually been either repeated or reiterated in some of the case law this year, or which is just really, really useful to bear in mind because they don't necessarily always make it into the white book or the commentary, and it's quite important just to make sure you're aware of it. Firstly, members of the public does not include local authorities. That is a fight that James and I have had, and we finally got there because the government changed. They finally changed the definition in the rules, because it was made very clear by the Aarhus Compliance Committee in the cases I've referred to on the screen there, which were the complaints to the Aarhus Compliance Committee about HS2 and the consultation process leading up to the command paper in 2012. I think we eventually got a decision about 2018-19 after I think it already had royal assent for the bill, but things don't always move very quickly in the Aarhus Compliance Committee. But that was where the court took head on, can we actually entertain a complaint from the London Borough of Hillingdon? Isn't the London Borough of Hillingdon actually a member, a public authority who would be on the other side, who has got obligations under the Aarhus Compliance Committee, not a member of the public who can make complaints about it? So that's now been clarified, but it looks like community and parish councils are included, and the case that's often cited for that is a case of Crondall Parish Council. Now, the citation I've given you on the screen, which I haven't underlined, is the 2019 citation is actually the substantive reporting of the case. The consideration of costs was actually done by John Howells QC, as he then was, on the provision stage on the papers, but in one of the cases I'm going to come on to a bit later, you do actually have a reporting of what he actually said on on the cost point in one of the later cases. So I'll direct you when we get to it to if you need to rely on Crondall, where you can actually find what was said in Crondall in the relevant bit, not in the reported judgment on the substantive case. Secondly, and I've alluded to this already, it's a common assumption that protections apply to all planning claims. And if you need the reference for that, because I had to go looking for it the other day, because I knew there was a common assumption, because I'd said so in a blog, and then I had to remember where I got that from. It's in the Venn case from 2015 in the Court of Appeal. And that was the case which sort of started off some of the changes to the definition of Aarhus Convention claim, because at the time it only provided for judicial reviews. And everybody went, well, what about 288? And the court went, well, you know, obviously in substance, but that's not what the rules say. And sorry, you're sort of stuck with what the domestic rules say, and we're not going to implement, you know, we're not going to implement the Aarhus Convention directly into UK law. The government's made a choice. If the wording is not wide enough, they need to sort that out in the rules. Also important to bear in mind, and I think this is controversial, and I'm also very cross because I lost the argument in this case, so you know I've got skin in the game on this one. But an application for a variation can be made by an interested party. The situation always seemed to be pretty clear under the rules that the cost caps for a claimant and a defendant, and the defendant could apply to vary, or the claimant could apply to vary. So it seemed quite nice to go, well, it doesn't say interested party, does it? But this came up in a permission renewal hearing, actually. And, you know, in the best interests of the bar, I properly drew attention to something slightly awkward that Lord Justice Coulson had said in the CPRE case about, oh, well, when it says defendant, it probably includes interested party as well. And that got legs. And so it's now established that an interested party can apply for a variation of a cost cap, even though the rules only expressly refer to a defendant. And something that's really, really important to bear in mind is that there's no difference to the usual summary assessment of costs where you've got a cap. It comes in afterwards. You just assess costs in the usual way. If it goes over the 5k, the 10k, whatever it is, it's a guillotine. You don't go about some wholly different exercise of going, well, because there's only £5 to play with, let's assess what the reasonable cost would be in the world where we've only got £5. And that's quite important because there's often historically been arguments about at permission stage. Well, you can't order 5k costs at permission stage because that's the whole of the cap. And that cap should have been there for the whole of the proceedings. So it's not a reasonable amount to order at permission stage that I pay 5k, because if I'd had a whole one-day hearing, I'd have only had to pay 5k. So, but the court said, no, that is just not the right approach to it. You assess costs in the usual way, then the cap gets applied. It's no difference in approach. And also important to bear in mind, the cost limits are inclusive of VAT. That was the Friends of the Earth case from 2021. Again, important because I've had people trying to reopen cost caps. Actually at a Supreme Court hearing, I think it was, or a cost cap at the Supreme Court stage, going, well, this should be revisited or reopened, because nobody knew when we set the limits that it included VAT, but the court slammed that one down there. But again, important to bear in mind, particularly if you're advising at the early stages. Now, moving on to what I'm actually meant to be talking about today. Oh, hang on, what have I done? I have actually broken the screen. Oh, no, hang on. There we go. Happy days. This is why there's also usually a keyboard. All else fails, whack the keyboard, but apparently not today. So I'm going to touch on about just 3 cases really from the last 12 months. Cut me a bit of slack. I know it says 22. I'm still catching up with the fact we're in 2025. And it was sort of November-ish, so it's kind of there. So Western and Cambridgeshire, I know it's been kicking around a bit, but it's useful to do a recap. This was a challenge to a traffic regulation order under the Road Traffic Regulation Act 1984. Now, the parties agreed that, having regard to what the nature of the claim was, it was an Aarhus Convention claim. It was a review under statute. It was to do with the environment. We don't get a lot of explanation for why, but the parties agreed. Now, the first issue in this case was who was the claimant. The claimant was recorded on the claim form as being Pamela Weston on behalf of the Friends at Mill Broad Bridge. That was an unincorporated association. She was the chairwoman. And there was just a bit of confusion about, can an unincorporated association be a claimant? Does it need to be a person? At the hearing, counsel very rightly said, look, it's Ms. Weston. We accept that. She's the one who's liable for costs. She should be the claimant. Now, the second issue that gave rise to was there was no schedule of financial resources on behalf of Ms. Weston. There was evidence in a witness statement about the resources that the association had, but there wasn't her personal resources because that hadn't been put in. And so the defendant argued, well, the court's got no power in this situation to make a cost capping order, because under the rules, you've got to state in your claim form that it's an Aarhus Convention claim, and you've got to file a schedule of financial resources. Didn't do that, ergo, can't have the cost cap. Relatively short shrift from the court on that one. Yes, the claimant should have filed and served a schedule of financial resources with the claim form. Yes, that is what the rules say. But a schedule can be provided late. And so essentially it's not a knockout blow to the court having a jurisdiction to make an order if you don't do it. But I'm not going to advise, it's always going to be better to do it. Do it. Don't rely on this as saying it's fine, we can put it in later. In that case, there was obviously a bit of confusion as to why it hadn't happened. And there may be some circumstances where, say, something's incredibly urgent or what have you, and it just needs to go in the next day or something like that. But although it's not a knockout blow, don't rely on the fact the court has said in principle it can be provided late. And also in that case, there was some information shortly before the hearing that had been provided about Ms. Weston's financials, but the defendant hadn't had a chance to consider it or decide whether to apply to vary. So the court bounced off the consideration of the substantive claim for a cost cap. But really useful in terms of looking at the ins and outs of the unincorporated association stuff. But why I think this case is particularly interesting as well is the defendant also made an application for security for costs under CPR Rule 25. Now, the court declined to make the order. It said it looked at the criteria and the rules, said, well, this one's not met and this one's not met. And there's quite a lot of consideration of that in the judgment. It's quite a useful little run through of it. And the court didn't actually need to go on to say, well, if those criteria were met, do we still think it's just to make the order? But the court was adamant, no, it's absolutely clear. I've got no hesitation in concluding it wouldn't be just to make the order. And a couple of things that I think are useful about here, which is that one, it was only because there had been the box tick saying, I want an Aarhus cost cap, that the defendant had any information at all about the claimant's financial resources. You'd not usually have that. Essentially, the idea is it looked a little bit opportunistic, going, aha, we know that apparently they've not got any money, so that's going to give us grounds for going for a security for costs order. And secondly, the court was quite alive to, I know this is secondly and thirdly, but I'm just paraphrasing. Secondly, the court was alive to the submission made very powerfully actually by claimant's counsel that, well, hang on here, this looks a bit awkward, because the whole point about the cost capping orders is that it's meant to ensure that people aren't disincentivized, that they're able to bring proceedings, that proceedings wouldn't be prohibitively expensive for them. How does that work? If I've suddenly got to hoik up all this money up front for security for the defendant's costs, how do I meet my cost bills? This just runs, there's a real tension here between what the Aarhus cost caps are meant to be for and making an order for security for costs. So I think the court had quite a bit of sympathy for that. But again, quite useful to have a look at if you're in that situation where somebody might be pushing for such an application, or you might be considering an application, to see what the court did and why, or what they were bothered by in that case. The next case to touch on briefly is Cottam School and Bristol City Council and others. Now, this was a straightforward, well, it wasn't straightforward because there were three based on which they sought a cost cap, but I'm only going to deal with Aarhus. Here, the school had made a Part 8 claim for an order under the Commons Act 1965 for an order to amend the Commons Register that was kept by the council to delete an entry that related to some playing fields, which they leased for school use, i.e. the playing fields were on there as being a common, the school wanted that deleted. And one of the things they sought was an Aarhus cost capping order. The court concluded the claim wasn't an Aarhus Convention claim for the purpose of Part 46. It got there in substance. The subject matter the court fell within Article 9.3. This was about provisions of national law related to the environment. It's about access to, public access to, use of land. That's Article 9.3. But Article 9.3 required decisions to be taken by the public authorities, which did include bodies or institutions acting in a judicial capacity. And that was what the court felt the situation was in the Cottam case, that essentially here, as a registration authority, the council wasn't acting qua public authority, it was acting as a sort of quasi-judicial body. And in any event, the court felt the claim wasn't either a claim for judicial review or a review under statute. It was a de novo application going to court saying, we want de novo you to consider whether this ought to be deleted from the register. So in principle, in substance, yes, these provisions fell within Article 9.3, but fell on the technicalities because of those points. There was also quite an interesting consideration of whether the claimant was a member of the public. And the defendant said, well, no, come on, they're an academy. And there's this case that I found from whatever date that says an academy is amenable to JR, it's a public authority. Court didn't have a lot of truck with that case. I'm summarising briefly, but essentially said, well, look, just because a body might be a public authority for some reasons, like a JR claim, or when they're acting as an academy and they're taking those decisions, that doesn't mean it can't be a member of the public when it's acting in another capacity. And in this case, it felt like the claimant was bringing a claim to vindicate its proprietary rights under a lease. It's not acting as a public authority, it's acting like a member of the public, like any other individual. So essentially, it's this idea has come back in, and it was mentioned in the Crondall case as well. This is the case that you go to, the Cottam case, if you want to find what John Howells actually said in the Crondall case that everybody relies on, because that's where they set out paragraph 14 of his judgment, I think, on that one. But essentially, it's this idea of hybrid authorities. There's some bodies that might look a bit public, might look a bit private. They might be public for some purposes, but that doesn't mean they're out of the protection of the Aarhus Convention for all purposes. So again, quite useful if you might be dealing with that sort of body that's got a bit of a joint or nebulous function. And the final case I want to touch on substantively, because I'm conscious of time, was the Friends of the Earth case. This was the one where I think Alex is still trying to get hold of the ministerial submission, if I remember correctly. They share a room. I mean, they're very good with their Chinese wall, that's all I'm going to say. But it's genuinely, I'm conscious that's being recorded. They are, you know,
Collusion.
walls are maintained at all times. We are absolutely religious about that sort of thing and militant about it. But the West Cumbrian mining case, in that case, what had happened was the Secretary of State had consented to judgment. The claim, however, continued to be resisted by the second defendant, which was the mining company. Holgate granted, sorry, Mr. Justice Holgate, Lord Justice Holgate granted permission and also an order quashing the decision. And the issue then came up as to the liability for costs that were to be paid by the second defendant who'd stepped into the Secretary of State's shoes. And it was really about, well, how many sets of claimants' costs does the defendant have to pay up to the 35k? And the court said, well, here there's two separate claims, so two separate representations. You can't just say only one claimant gets their cost. That's not how this works. If there'd been no submission to judgment, then the Secretary of State would have had to pay C1's costs and C2's costs. And the second defendant's in the same role, same position as the first defendant would have been. And the cost capping order expressly provided for the separate cost caps in each of the claims. So claim one, claimant one, they had a cost cap. Claim two, claimant two, they had a cost cap. You can't just put the two together. These are separate claims. It's not one claim, one claimant. So basically the rules didn't provide for the court to treat the claims as a single claim, and the defendant was on the hook for the larger amount. And just in terms of that case, it's a timely reminder that firstly, you determine liability first and then you apply the cap. So it was the point I was mentioning earlier. But secondly, the fact that you've got different cases that are case managed together, so claim one with claimant one, claim two with claimant two, doesn't mean you only get one cap for Aarhus purposes of their separate claims. So think about that when you're bringing your claims or defending your claims. The cap applies per defendant, unsurprisingly, and stepping into a defendant's shoes or the D1's shoes will put an IP or a second defendant at risk from that point forward up to the limit of their individual cost cap. Finally, I'm not going to touch this in any detail, but was another quite interesting case potentially floating around at the end of last year, which was in respect to the Tottenham Hotspurs case. The claimant said it's an Aarhus claim. The decision was about the defendant council's decision to dispose of open space, removing public trust over the land. Defendant and IP disputed it was an Aarhus Convention claim. Mrs. Justice Lang thought it was, but said, well, look, there's provisions. If you don't agree with me, you can reapply to have that reconsidered. There was an application, or there were applications, agreement was reached, so it wasn't considered. But I think Wilkinson and Cottam, and I've seen it in another context recently, I think there's a bit of an interesting issue floating around about where it comes to status of land, as opposed to changes to land or development of land. I think that's an area that's ripe for a bit more explanation as to whether or not these are Aarhus Convention claims or not. Potential changes afoot. Now, James is going to touch on this in a bit more. Obviously, we had the government call for evidence asking an awful lot of questions, which closed on the 9th of December. Now, we don't have any indication, and I've checked again today, when we might get any decisions on that. But there could potentially usher in some quite substantive changes to the current regime, so it's worth keeping an eye out. And that includes on things like, might the cost cap be extended to private nuisance claims? What's the situation with unincorporated association? Variation of cost caps, should the rules on that be changed? What about costs for proceedings with multiple claimants? Should the appeals rules be clarified to make it clearer how that ought to be dealt with? What about cross undertakings and damages on interim injunctions? And cost orders for or in favour of interveners? So quite a lot of material, I imagine, that the government is chewing over, and potentially some quite big changes that could be coming down the line. On that note, I'll hand over to James.
Thank you. So as I said earlier, I'm going to cover non-costs, domestic and European case law on Aarhus in 2024. And that's going to involve looking at four things, really. First of all, the status of the Aarhus Convention in our law. Secondly, Aarhus and the Wednesbury test, which Alex has already touched on. And thirdly, to round up on some other domestic Aarhus cases in 2024, before looking at some cases from the European Court of Justice that have dealt with Aarhus over the last year, if I have time. So I'm going to start with the status of the Aarhus Convention, and the central case here that we've had in the last year came out in December, which is Shell Persons Unknown. And this is obviously one of the protester injunction cases that we've seen over recent times. The judgment was really focused on the role of the United Nations Special Rapporteur on Environmental Defenders, which is an office established under the auspices of the Aarhus Convention. And there is an extensive consideration of Aarhus matters in what is a very, very lengthy and detailed judgment. But the bit that I'm interested in is not really about the Special Rapporteur, but about what the court said on the role of the Aarhus Convention in our domestic law. Now, there is case law, for example, the case of Morgan in the Court of Appeal, that looked at the status of the Aarhus Convention in our law, but pre-Brexit, when Aarhus had a particular role to play through EU law in this country. This judgment's interesting because it's now looking at the position post-Brexit. The Aarhus Convention, to the extent it's not incorporated, of course, the costs provisions are incorporated into our cost rules, but lots of other parts of the Aarhus Convention are not incorporated. And so they cannot be directly applied in domestic law. The question is, what relevance can they have? And as the court pointed out, that question is dealt with more generally by the Supreme Court in SG. And what was relevant in that case in particular was that in considering convention rights under the European Convention, through the Human Rights Act, you can have regard to other international law conventions, including in environmental cases, the Aarhus Convention. Now, the court gave the usual warnings about not using an international convention like Aarhus to give rise to surreptitious incorporation. You can't use the common law to try and incorporate through the back door unincorporated international conventions, because Parliament could have chosen to do that, and it has not. But notwithstanding that, what the court held, this is quite a long paragraph, but in essence, what the court held was you could very much have regard to the Aarhus Convention, including all aspects of it that are unincorporated, in having regard to and considering issues around the Human Rights Act and the relevant articles. Now, I think Alex will particularly like one bit of this quote where the judge said, to repeat the three pillars of the convention are. I've actually got judicial authority for your talk now, so that's good. I'm glad you've got that. In addition, what the court said, and I think this is where it becomes quite interesting, is because you can have regard to the Aarhus Convention in considering European Convention rights and proportionality analysis, that means by definition in the context the judge was considering, that where the court has a discretion which it's considering exercising, the Aarhus Convention is going to be relevant to the exercise of that discretion through the lens of the European Convention. So that's the status of the convention. I want to talk about Aarhus next, and obviously the best named case of 2024 was definitely the Fighting Dirty case. I mean, it's a great name for a case. It's a great name for a company that's obviously dealing with waste. I mean, the waste companies come up with the best names, they really do. Anyway, Fighting Dirty case, Mr. Justice Fordham. The challenge included, it was a challenge to an Environment Agency decision. There was a Wednesbury ground of challenge, and Mr. Justice Fordham, in his normal comprehensive style, dealt with the issues around what is the standard of review in an environmental case, and in particular in a case where Aarhus is engaged. And he looked at the previous case law because there was a bit of a conflict at High Court level between the McMahon case and the Dillner case about whether there was an enhanced standard of review in environmental cases that fell within the scope of the Aarhus Convention. Now, obviously, there is a tie-in here to what Nick's going to talk about, which is the ongoing proceedings before the Compliance Committee about our Wednesbury test and its compliance with the Aarhus Convention. But what I can report to you before I turn to the conclusions of Mr. Justice Fordham is, contrary to the suggestion that Alex made, Wednesbury is not dying and on its way out. It's very healthy and likely to be remaining with us for a long time. Now, what the judge said was that just because a case is an environmental case and an Aarhus case doesn't automatically mean there's a higher standard of review. That doesn't follow for reasons which he explains, I think, quite convincingly in some detail. But because environmental cases can involve very serious environmental problems and impacts on rights, etc., then it is quite possible that you will get to a position where you take the view that there should be a more stringent standard of review. Still Wednesbury, but Wednesbury is a flexible form of review. And he said he wouldn't accept that in the context of environmental protection, one must focus on human rights. He refused to accept a submission that environmental protection is not a matter which does not raise issues of real importance to individuals. He said this is all about rights, and more importantly, Wednesbury is a flexible standard of review. Aarhus is something one feeds into this, but the reason Wednesbury still works is that you can vary the standard of review depending on what's in issue, and in an environmental case that may often be the position. So, I mean, it's useful, I think, to tell us that one, Wednesbury's here to stay, but two, it is a very variable standard, and it may well be, in the light of this case, that there will be an increasing number of arguments made that the court should, in an environmental case, be applying a higher standard of review. The judge said, I think most importantly, I do not accept this is a case where the judicial court needs more in terms of the strength of reasons required to justify the agency's actions, nor that the context and circumstances serve to narrow the width of the latitude afforded to the agency. So on the facts of the case, he wasn't terribly persuaded about there being a need to apply a much stronger review. I mean, one might think that's not surprising given what one was talking about was a waste company challenging environmental regulation by the Environment Agency, but that was the context in which it fell to be decided. Now, a few other cases, I mean, Finch, much discussed this year. There is a particular role for the Aarhus Convention. It gets cited in a number of places. It's something that we've already done a blog on. I won't talk about the detail of it now. But I think in terms of the great victory in Finch as it's seen by those who won, or the appalling mess that's been created, as has been very much articulated by the minority view in the Supreme Court, the truth is Aarhus played a role both substantively in the decision, but also, of course, Finch herself had Aarhus cost protection, and seems unlikely the claim would have been able to get to the Supreme Court without that. I then come back to remind Alex of his failure to obtain the ministerial submission in the Cumbria coal mining case. That was that application, which I again reiterate failed to obtain the ministerial submission. Did in part rely upon Aarhus, but the court rejected all the ways in which it was put and found there was no requirement to disclose the ministerial submission. And I think in the context of a case where you've got an inspector's report and a decision letter, I think that's a pretty clear and cogent and correct decision. It may not be quite the same if one's dealing with decision making that doesn't have those stages in the process. So I come to reforms. Two things are relevant. First of all, we've had the Banner review, which is looking at challenges to principally to DCOs under the Planning Act 2008, so nationally significant infrastructure project consenting decisions. One of the things that was looked at by the Banner review, and the Banner review was, of course, Lord Banner and Nick Grant, who's sitting over there, but one of the things that they looked at was, should we do something about costs? And effectively the answer was, well, actually, so long as we're still part of the convention, there probably isn't much room to muck around with the cost caps in these cases. And clearly the perspective that was taken in this review was that there are a lot of challenges to DCOs. They're holding up infrastructure projects. These actually cost millions and millions by delaying projects. Is there a way in which we can effectively prevent this happening? Now, in addition, there is a recommendation in there about having different rules for the permission stage in relation to NSIP judicial reviews compared to other judicial reviews. And some respondents, I think, suggested that that might itself be a breach of the Aarhus Convention. The Banner review rejects that for the reasons that I've set out there and says Aarhus could allow you to have a different standard of permission in relation to NSIP cases, and indeed less opportunities to obtain permission. Perhaps we spend just a little bit more time on reforms. This has already been mentioned. There's an open call for evidence on Aarhus, or there was up until the 9th of December, as Jacqueline mentioned. Now, this is because there are a number of outstanding findings of breach of the convention by the UK in various Aarhus Compliance Committee decisions, some of them quite historic now. And this really invites views on whether the government should be doing something to deal with the concerns that have been raised by the Compliance Committee. Now, one of them is about judicial review time limits. That's the second one. So the Compliance Committee seemed to have an issue that in our public law, time runs from the date when a decision's taken and not from the date when it becomes known. So that's one thing they're talking about. Do we need to change our JR time limit rules? There's also unbelievably a consultation about whether our litter abatement orders are compliant. I mean, I won't spend time on that, but the key one really is the first one, which is the environmental cost protection regime. And the reality is that the Compliance Committee are unhappy with the scope of the claims covered, the default levels, the ability to vary the caps, the requirements for the financial resources to be made available, the cost for the procedures where there's multiple claimants, the costs in relation to determining an Aarhus claim, cost protection on appeal, and cross-undertaking damages. I'm not sure what they actually thought was acceptable within our regime, but those are the things they didn't find to be acceptable. The truth of the matter is, in my personal opinion, the Aarhus cost rules are working very well. Indeed, I think Alex's presentation agreed. Aarhus is working, I think was one of his comments. And it is working. There are a huge number of environmental claims, and I'm not sure there would be that number if we didn't have the Aarhus cost rules. I don't think the rules need tinkering with further myself, and I think they work pretty well. But how we deal with the fact the Aarhus Compliance Committee doesn't agree is obviously an issue that will have to be bottomed out by the government on their lengthy to-do list. So I'm just going to mention a handful of CJEU cases from this year. I mean, it's interesting, isn't it? We all look a lot less often now at new cases from the European Court because they are no more than persuasive authorities now. We might equally look at Commonwealth authorities or other case law from other international jurisdictions. I just want to touch on a few things. So first of all, there's a couple of cases which Nick drew my attention to, which are looking at the interaction of the Aarhus Convention and the Habitats Directive. And that will, I think, remain relevant to us, at least to some degree, because obviously we've retained the Habitats regulations which implement the Habitats Directive. And these cases are effectively looking at what within that field of decision making under the Habitats Directive is within Aarhus, and I probably haven't got time to say more about those, but if you are looking at an issue of interaction between Habitats and Aarhus, these are probably the two European cases from this year to look at. Then a couple of other cases, one from Romania in particular, which really looks at the fact that some of our European neighbours do take a much more restrictive view about the ability of NGOs to bring challenges. We obviously do not have a restrictive approach at all, and NGOs bring lots and lots of challenges, but in other countries, not so much. Then in addition, the Civila Professional case is another case where, again, you're looking at the standing rules, and our standing rules are much more liberal than our European neighbours. This is an interesting case about whether a solicitor's firm had the ability to effectively bring proceedings challenging matters related to the environment, even though they weren't an NGO in the classic definition of an environmental NGO. And of course, not surprisingly, the court took quite a sort of dim view of limiting for proceedings to be brought by these other organisations. Of course, notwithstanding the fact that CJEU has itself had some of the most strict standing rules of any court for many, many years, but there we are. And then a couple of cases that have just looked at the scope, really, of the Aarhus Convention. Cases looking really at what falls within environmental information, and there's been two references before the European Court that have looked at the scope of environmental information for Aarhus and EI directive purposes. I won't talk about those any further. I mean, you'll see the bottom one was about standards for chemical toy sets. I mean, it's amazing what the EU regulates, but I was thinking about those little toy sets you used to get as a kid where you could do little experiments with Bunsen burners. I guess there must be environmental issues about those. I don't know what they are, but emissions, I guess. I don't know. You have enough children burning things. It's the same as a factory. Anyway, I don't know what the issue is. And then finally, there's a few cases on the Aarhus regulation. And the Aarhus regulation has really become a big thing in the time since the UK left the European Union. It effectively allows individuals and NGOs to seek environmental information from the EU institutions, and there are remedies if it's refused and your review fails before the General Court in Luxembourg, and the General Court hears a lot of cases about these procedures, and I've given you just a handful of the cases we've had in the last year that have looked at whether certain information that's been requested falls within the scope of environmental information or not, such that it should be given up by the institutions. And then finally, before I finish, Aarhus has also played an important role this year, and I mean this ties in with the discussion about the status of the Aarhus Convention. If you want to look at how Aarhus can influence the scope of the European Convention, you only have to look at the Swiss and the Portuguese cases before the European Court. They made multiple references to the terms of the Aarhus Convention in reaching the conclusions they did on climate change issues. So far, though, despite the great excitement about the Swiss case, not really made much of an impact in our domestic law. The only case where I've seen any kind of substantive consideration of it is this failed Friends of the Earth challenge. And the claim, which was pursued on climate change for human rights grounds, failed as it did on all the other grounds. So I'm going to hand over to Nick.
Will you, if I can't get out? Cool. So we've heard a bit about what the Compliance Committee has been mentioned a couple of times this evening, and I'm going to look at the roundup of effectively what's come before them in 2024. Now, for those that don't know, obviously the Aarhus Convention, as Alex told us, is an international treaty. Member states tend to be, state parties rather, tend to be really precious about whether they're complying or not. So they all got together in the meeting of the parties and set up this Aarhus Convention Compliance Committee. This is basically a committee of 9 members. The committee takes communications from the public or can investigate things off its own back, usually takes submissions from the communicant, often an environmental NGO, the state party in response, and comes out with a lengthy opinion about whether in a particular way, and I'll come to some of the examples of how that's being used, but whether in a particular way the state party is complying with the Aarhus Convention or is not complying with the Aarhus Convention. They're not a court. That's not the end of the matter, given that it's an international convention. There isn't, it's not the International Court of Justice, but these reports then get either approved or disagreed with down the line at meetings of the parties when all of the members get together. And if they're agreed with, they become an aid to interpreting the Aarhus Convention. So that's why it matters. And as James has touched on, in domestic law, ideas and opinions of the committee is seen as persuasive, or at least worthy of respect. So that's the committee and that's what it does. As you can see on here, there are 45 open complaints. The earliest one, and by open complaints, I mean one where they haven't reached a decision yet. The oldest goes back to 2014, so almost 9 years. And there are 4 open against the UK. We haven't seen any action on those this year. This is really just to give you an idea of how the Aarhus Convention is being used. Some might say abused. So the first case against the UK is the withdrawal bill case. Now, this is basically a claim brought, I remember who brought it, the NGO, saying that the UK should have consulted on the what became the Withdrawal Act, at the time was touted as the Great Repeal Bill, whilst it was being drafted. So before it goes into Parliament, whilst it was being drafted, they're saying the UK should have consulted and are relying on Article 8 for that. If the committee finds against the UK on that, there will be quite the loggerhead, because in domestic law, it's pretty trite that the High Court is not going to force the government to consult on domestic legislation before and domestic primary legislation before it goes into Parliament. So a real showdown there between our domestic position and the reach of the Aarhus Convention. The second, which James has touched on, is the Wednesbury case. Because he's spoken about it, I'm not going to. The third is the Free Trade Agreements case. And again, this is a complaint brought, I think, by WWF. And they're saying there needs to be greater consultation on free trade agreements. The current mechanisms out there by which our ministers and civil servants negotiate these trade agreements are not good enough. They have a significant environmental effect. There needs to be full and proper public consultation. Now, the last is the planning appeal rights case. And this relates to Scotland, but similar position in England. If you apply for planning permission and your local authority says no, if you're an applicant applying for the planning permission, you get to appeal to the Secretary of State and you get a full rehearing on the merits. If the local authority says yes and you're a local objector who doesn't want it, all you can do is commence a judicial review. You can't go to the Secretary of State. And what's lying behind this complaint in the planning appeal rights case is they're saying that's unfair. It's two-tiered, it's not okay. I can't remember which provision of Article 9, but it's not fair and equitable for objectors to have to go to court, to incur the costs of going to court, counsel, solicitors, and for appellants to just get another free go. So we'll look forward to seeing when the committee comes down with those, quite possibly not soon. I feel for them. There's only 9 members of the committee, and because one of the reasons you can kick a complaint out is by saying that there isn't enough evidence in support, usually complaints and then the response of state parties deluge the committee with lots and lots and lots and lots of paper. When James and I were last there, they said, please, 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 stop giving us so much paper. Seriously, we can't keep up. So not their fault. As I say, there's only 9 of them, including Eleanor Sharpston, who some of you may know, former Advocate General of the EU. But that's basically where we are in terms of the domestic side of things. So this is a review of the year. Turning then to the cases that the committee has handed down this year. None. Thank you very much. There have, however, been 5 complaints to the committee. And again, this gives you a bit of an idea about how the Aarhus Convention is being used across the state parties. And it gives a bit of an idea about how it might be used, particularly by ENGOs in the UK. So the first one is a complaint against the EU. Now, basically, this relates to the San Finks tin and tungsten mine in Spain. The mine has 8 levels. 4 of them are, as a matter of just their domestic nature, not in use, they're not flooded. The EU is funding a project which requires use of the 5th level, and water is being pumped out of that into a river without discharge permits, or indeed any sort of public consultation. Local NGO has asked the European Commission for information relating to this, given that it's a project the EU is funding, and the European Commission said no. They went to the Aarhus, appealed under the Aarhus regulation. The appeal said no. They didn't take it to the CJEU, that they could have done, but they did complain to the European Ombudsman. And there are a couple of interesting fights happening in this case. Now, the first is a fight about admissibility, because this, although it's been found admissible subject to review of the EU's position, the EU is saying, no, this isn't an admissible complaint. Effectively, there's a dispute about whether there is a strict requirement to exhaust all domestic remedies. So as I said, they didn't go to the CJEU, they could have done, and the EU is saying, therefore, this complaint isn't admissible. There are other fights about costs, which will be of great relevance to us, but I'm not going to go into now. On the substance of it, there is a question, the EU saying this isn't environmental information, because what you're seeking is things like business plans, business activity, choice of software, materials and methods. This is not environmental information. This is confidential proprietary information about a business. So they're saying this doesn't come within the scope of environmental information. One can easily see how a similar fight might take place in the UK. Second fight, or second case, is a case in Germany. Now, this relates to a piece of secondary legislation that was enacted after Russia, I think it's secondary legislation, might be primary legislation, but enacted after Russia invaded the Ukraine. Germany is obviously very reliant on liquefied natural gas as a resource, and so it passed the Liquefied Natural Gas Acceleration Act in 2022. And this is intended to accelerate a number of LNG projects, pipelines, floating storage, I don't know what the technical term is, floating storage thingies, and onshore, offshore terminals. There are a number, so the complaint is brought by Green Legal Impact Germany, effectively saying that in a number of ways this doesn't comply with the Aarhus Convention. So, for example, for a number of these projects, which would be EIA projects, the consultation period is being shortened from 6 to 8 weeks to 2 weeks. They're saying that's not compliant. Certain projects are exempt from EIA at all, even though they would be EIA within standard domestic German law. The public wasn't allowed to participate in the drafting of this act, or at least not effectively, they say. So that's a breach of Article 8, similar to our Brexit case. And fundamentally, they say that this act determines the need and desirability for liquefied natural gas, which means we can't participate down the line and say, you don't need liquefied natural gas anymore. They're saying it's a big breach of their ability to public participation, and therefore that's breach, again, an article, a breach of Article 6. Of particular interest to us, the Act allows for a number of what are they called? Early start approvals, so things that we might see on a planning permission, early works, without public participation at all. And it obviously restricts who can bring a JR, trying to countermand all of these. So that, they say, is a breach of Articles 9, 2 and 3. The complaint's admissible. We've not seen the German response. On to Italy, and this complaint concerns a decision to open a tunnel. So this tunnel's been ongoing since the 80s, the construction of this tunnel. It isn't new. Work began during the 80s. It's not been complete yet. One tunnel has been completed in 2006, and this is basically joining the regions of Marche and Umbria, or however they're supposed to be pronounced. And I'll look at James with his Italian heritage. In 2023, the decision was made to open this one tube to one-way traffic going from Marche to Umbria and connect it to the existing road system. It's not entirely clear from the complaint whether this was literally just okay, we're opening this tunnel, or whether it also consented additional works. I couldn't really tell. But effectively, you've got a bunch of local residents getting together and saying, hey, we weren't consulted about this, we didn't know about this. The first we knew about this is when it was published way after the decision's been taken. Again, standard breach of Article 6. All of the public participation in this EIA project. Fourth of 5 is a complaint about Ukraine. It comes from the NGO Save Dnipro. Again, post-Russian invasion, we're all aware of the difficulties Ukraine is facing, and what NGO Save Dnipro is trying to do is trying to get information out of the Ukrainian ministries, environmental information about the location of industrial facilities and energy facilities that would be of interest to the Russians. I think the way it's being pitched in the complaint is members of the public need to be able to get this information so that we can move away, basically. The Ukrainian ministry is obviously restricting that information. It's saying no because there's a war on, or providing very much redacted information. But in effect, the committee's dodged this one because they said it's inadmissible because there hasn't been enough supporting evidence supporting the complaint. So that one's not gone further, but again, only on a technicality. And again, rather emphasises why when people are making a complaint or responding to them, they deluge the committee with documentation. Last one is a complaint about the Czech Republic. And this is a piece of delegated legislation, but it's set up effectively under the Nuclear Act, and it's designed to allow the siting of deep geological nuclear waste repositories effectively. What the Act does is it deliberately doesn't allow for public participation at the early stages. Basically, when they're picking the place where these repositories are going to go, there isn't public participation allowed in that. Public participation comes later at the EIA stage. There is an explanatory memorandum to the local legislation, and it pretty ballsily says, yeah, we're doing this because frankly, the public's just going to be quite irritating. They're going to put forward their own private interests. No one's going to care about the national interests, so why bother? I understand. I'm not saying I don't understand, but it's quite something to try and make a law on that basis. And as you might imagine, there have been a lot of complaints saying effectively this is non-compliant with Article 3, Article 6, and Article 9. So that's pretty much all the open complaints that we saw this year. But looking ahead, what are the future communications? Well, as the review of, I hope this year and the open complaints against the UK, there's quite a lot of inventive stuff going on, trying to against national authorities. I'm not going to predict the way this is going to go for inventive, particularly NGO sector in this country, but there's quite a lot they could be doing. Where I do think we're probably going to see a complaint is in relation to environmental protesters. Now, James has already touched on this because the special rapporteur, who is set up as a special rapid review mechanism, has already written to the UK saying he is very concerned about the treatment of Just Stop Oil protesters. And the points he's raised are the fact that they can be subject to civil and criminal proceedings because National Highways gets injunctions over their road network. And if you breach those civil proceedings and criminal proceedings, the disproportionate, his words, not mine, sanctions of 10 years in prison and unlimited fine, the significant delay for criminal trials, in fact, this is hanging over accused, the excessive costs for contempt proceedings. And as an example of the excessive costs, in the civil proceedings, 2 awards were made, one of 3K and one of 3.5K, and those he considered were excessive. The National Highways bill overall was 230K, but they only sought 59, and that got knocked down to 3 and 3.5. The idea of custodial remand for peaceful protesters is something he's concerned about. Harsh bail conditions, delays in criminal trials, the disclosure of confidential police records to National Highways. All these things are things that he says are a breach of Article 3.8 because protesters are being persecuted, in his view, for exercising their rights under the convention. Now, there is some ping pong going on between him and the UK at the moment. We'll see where that ends up, but he can refer things to the committee, and if he doesn't, I imagine it's only a matter of time before an NGO will. So if I had to put my money on it, I would guess that that's the next complaint against the UK. Of course, be others. So that's pretty much whistle-stop tour of the year in review at the committee stage. I'm back to James.
So I don't think we've had any questions from those who are online, although I didn't get a chance to. Someone could just keep an eye on that. Has anyone in the room got any questions they'd like to ask any of the panel of speakers? You are not allowed to ask Alex how many pillars there are in this convention, but apart from that, are there any questions? No, I've answered all your questions about Aarhus. Okay, well that's great. Well, thank you very much, those who attended in person and those who joined us virtually. I think I'm right in saying that there are drinks outside. Is that right?
Some canapes, I think.
Some canapes and some drinks outside. So please join us for those. And if you've got any questions that you didn't want to ask here, then you're welcome to ask us outside. So thank you very much, and thank you for attending.